Madam Deputy Registrar, would you please begin the proceedings?
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction, an appeal from the Court of Appeal of Guyana. Hearing of the appeal in CCJ Appeal GYCV number 9 of 2021 between James Ramsahoye and the Guyana Revenue Authority. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, everyone.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Mr. Justice Barrow.
Good morning to all.
And Mr. Justice Burgess.
Good morning, Counsel.
May we have the appearances, please? Thank you.
Your Honors, I am C.V. Satram, and I appear together with Mr. Rupnarang Satram and Mr. Ron Motilal for the appellant.
If it pleases Your Honors, I, Judy Stewart Adonis, appear in association with Ms. Hesson Yassin Nadalal and Ms. Marita Halley for the respondent.
Yes, good morning to you all again. Mr. Satram, are you ready to begin?
Yes, please, Your Honor. Good morning, Your Honor.
Mr. Satram, before you start, could I ask you, we got this order given by Mr. Justice Chang in 2005.
Yes,
just to get an idea of what this is about. It said that there would be a stay of execution of the judgment of Justice Persaud, but there were two conditions: that a monthly pension would have be paid to Mr. Ramsahoye, and that the Guyana Revenue Authority would deposit the total amount of 45 million in some deposited in an interest-bearing account. Did that all happen? And I also noted that in the last sentence of your submissions, written submissions, you mentioned something about the pension which was ordered by the court in appeal in 2004, had not been paid since July 2018 as the subject of further proceedings. Apparently that pension has been paid till July 2018. Does that have anything to do with this order? Could you give us some enlightenment about this?
A stay was granted subject to two conditions. We are aware that the first condition was met because, as Your Honor just said, the pension was being paid up until July of 2018.
By whom?
By NISIL.
Okay.
By who? By whom?
By NISIL, the national government-owned company that took over the assets and liability of the now defunct Lynn mine. I'm not aware, I wasn't able to confirm whether these monies, the 45 million, was indeed lodged. The registrar...
Who would know that? If you do, you can't find out.
Ms. Adonis Stewart, Stewart Adonis, would you be aware?
Yes, please, Your Honors, if I may assist this honorable court, last evening I was informed by the registrar that the monies has been lodged. So it's in the custody of the registry, please, Your Honors.
Can you say when they were lodged?
I am sorry, Your Honors, I didn't hear that.
Go ahead, Justice Anderson.
My question was, can you say when they were lodged?
I I'm unable to please your honors, but I rather suspect that pursuant to the order, at the time the order was made, the respondent would have complied, please your honors.
Thank you.
Thank you, your honors.
And Mr. Satram, the proceedings you talk about with respect to the payment of the pension, that is something between Mr. Ramsahoye and that government-owned company?
Yeah, yes, please, sir.
Okay.
It had come before your honors before.
Yes. Okay.
So why did the pension stop in 2018?
Your honors, we had applied. The Court of Appeal had made an order. A judge in chambers in the Court of Appeal had made an order for it to be paid by NISIL. And the full bench of the Court of Appeal had reversed that order on the basis that the single judge did not have jurisdiction to do so. We had applied for special leave to your honors court to challenge that decision, but we weren't granted special leave. And since the refusal of that special leave application, they've refused to pay the pension. So we're now in another battle to secure the payment of that pension. It is unrelated to what is happening here, but they're all related proceedings in some sense. There have been many proceedings that have been filed involving these parties, all aimed at securing the payment of the monies awarded by the Court of Appeal in 2004. But Your Honors, we will look at the implication of this, the lodgement of the monies with the registrar shortly, but 17 years ago, the Commissioner General demanded and collected about $45 million in taxes purportedly due to the revenue by the appellant. The monies were demanded from the taxpayer's employer, and it was paid by the employer out of judgment monies due to the appellant. There is no doubt, Your Honors, that the appellant was entitled to the monies demanded and received by the respondent. The demand was directed to the employer was made by a letter dated the 29th of September 2004, I believe. It is found at page 67 of the record. There was an earlier letter dated the 18th of August 2004 at page 68, to which were attached certain computations of income taxes for years of income 1996 to 1998. The total sum supposedly due for those years was given by the Commissioner at about $6.5 million. And in that letter, the Commissioner gave an undertaking to mail notices of assessment to the taxpayer. That never happened. He then engaged the employer, Linmine, in computing the tax liability of the appellant.
Sorry, just for clarity, Mr. Satram, yes. You said he gave an undertaking to send a notice of assessment?
Yes, sir.
To whom did he give this undertaking?
To the taxpayer, please.
Okay.
The letter is that...
Counsel, sorry. How was the letter which was sent to the taxpayer headed? Wasn't it headed assessment?
It said income tax assessment.
That's right. And the undertaking, quote unquote, wasn't it that a formal assessment would follow?
It says so, yeah.
Yeah, so it's not quite correct to say then that an undertaking was given to give an assessment. It was an undertaking to give a formal assessment. And while I'm here, is there anything in the Act itself which talks about a formal assessment? Is there anything that talks beyond an assessment?
No, please, Your Honor. The Act, as far as I can tell, does not make a distinction between a formal and an informal assessment. It speaks of assessment.
Thank you very much.
On which page of the record is that to be found, and that letter, Mr. Satra?
Page 68, please, Your Honor.
Okay, thank you.
That's all right. Now, the commissioner, as I was saying, Your Honor, engaged the employer in computing the liability of the appellant. And the calculations then extended to include taxes for the period from 1990 to 1998, as well as taxes on the damages awarded to the appellant by the Court of Appeal in the form of 41 months' salary. The appellant only became aware of what the commissioner had done in a letter from the employer addressed to his counsel dated the 12th of October 2004, and that letter is at page 55. The letter of August that I just referred to on, in respect of the 3 years' income, which is headed income tax assessment, could not serve, in our respectful submission, as the basis for the demand for the $45 million in taxes, which was actually collected. That letter of 18th August refers to 3 years, 96, 98 inclusive, and reflects a computation of about 6.5 million. The engagement between the commissioner and the employer resulted in a tax computation, which he later demanded, of 45 million. So in our submission, even if that letter of August is an assessment, it is not an assessment in relation to the taxes which were actually collected. 45 million was actually collected, and that letter only referred to about 6.5 million. Now, the commissioner claimed in that letter, in his letter of demand, that he was acting pursuant to powers given to him by Section 93 and 102 of the Income Tax Act. Now, in June 2005, the High Court quashed the decision of the commissioner contained in his letter of September 2004. And the commissioner has not since then raised any assessment. Justice Prasad, at first instance, found that the commissioner did not comply with certain statutory procedures set out at Section 70 and 72, etc. of the Act. The taxpayer, Your Honor, has raised a claim in its motion that the commissioner was attempting to raise an assessment outside of the 7-year limitation period created by the proviso to Section 72. And the response of the commissioner at paragraph 17, page 77, is that the record of the Court of Appeal revealed that the appellant committed fraud or gross or willful neglect. At page 145 of the judgment of the record of the judgment of the High Court, the judge said that he was unable to make such a finding based on the evidence before him. There was no evidence to support that allegation. At paragraph 9, Your Honors, of his affidavit in answer, at page 75 of the record, the commissioner also deposed that Lynn Mine could not deduct PAYE taxes because the appellant was not being paid at the prescribed time. Those are his exact words. That was his answer to the claim by the taxpayer that the liability to the taxes rests with the employer, where the employer fails to make the deduction. About 15 years after an appeal was filed against the decision of the High Court, the Court of Appeal found that the first instance judge was correct to quash the decision of the Commissioner, but to tell that he was wrong to hold that the damages were not taxable. The Court of Appeal did not address the limitation argument nor the question of whether the employer was liable for the Paye deduction. What they ordered at paragraph 15 of their judgment at page 31, paragraph 31 of their judgment, rather, page 15, was that the assessment must comply with the procedures and processes established under the Act. If your honors look at the order of the Court of Appeal as entered at page 17 of the record, after saying that the appeal is allowed in part, the only further order they made was that the provisions of the Income Tax Act as to notice of assessment, objection, and appeal must be complied with in relation to the respondent.
Okay, just stick a pin there. Did you understand that to mean that the assessment or purported assessment was quashed and that a fresh assessment needed to be made by the revenue?
Yes, sir. I understand it to be saying that the commissioner was free, at least, to make a fresh assessment.
And has any fresh assessment been made?
No, sir. But the submissions of the respondent, Your Honor, will see at page 884 of the record, in its conclusion, is that this court should, in the interest of justice, order that a formal notice of assessment should be served in the appellant. So I think they understood it that way as well. The cross appeals that were filed in this case, as Your Honors are aware, have been withdrawn. So there is at present no challenge to the concurrent orders of the courts below quashing the decision of the commissioner. And there is also no challenge to the concurrent findings of the courts below that the commissioner breached the statutory procedures set out in the Act.
Counsel, if I may, just a follow-up question to the President's question to you.
Yes, sir.
Assuming that the income is employment income, that the receipt was in the nature of employment income, yes, doesn't that become taxable ipso facto, ipso jure, as a matter of law? Doesn't that become taxable, assuming it is that the receipt is the income receipt? Doesn't it become taxable and remain taxable?
Well, the submission, I understand your question. The submission we make is that even if it was taxable in 2004, when that purported assessment was raised, it is now not taxable because of the length of time that has passed. The question, two problems arise out of what happened in the Court of Appeal. The first is whether, as Your Honor is asking, whether the commissioner can now raise an assessment in respect of any income or damages which he sought to assess 17 years ago. And the second problem is what was the impact or consequence of the quashing order, and specifically, did it entitle the appellant to the return of his money? Those are the two problems as I see it. that we have to deal with in the matter, because we have recently discovered, Your Honor, that as a condition of the stay, the Court of Appeal ordered that the monies be lodged to the registrar, the interest-bearing account, pending the hearing and determination of the appeal. We've just been told that it was lodged, and that is something we can confirm officially. So what that order did is it basically divested the revenue of the monies. And it became, in our respectful submission, imperative for the Court of Appeal, at the conclusion of the appeal, to deal with the question of what happens to the money. It can't remain there, because the order was it is to be lodged until the hearing and determination of the appeal. The appeal was determined, and this question was not dealt with. So, two things that could have been done, at least. The court could have ordered that it be paid over to the revenue, or it could have ordered that it be returned to the taxpayer. And our submission is that the court could not order that it be returned to the revenue, because it could not do so in the absence of a lawful assessment. The court was itself saying, listen, that assessment is null and void. And the revenue has no entitlement or no lawful right to retain someone's money unless it is done pursuant to a lawful assessment. And as we stand, there is none. And at the time of the determination of the appeal, there was none. So the effects of the order of certiorari meant that there was no assessment. Now, in our submission...
Just to follow on from what my brother Justice Burgess was asking, and this is not a question necessarily he was asking, but it occurred to me, the money obviously has not been paid over to your client.
No, please, not at all.
Okay, but we heard a few minutes ago that it is in the, I presume, the interest-bearing account.
Yes.
So if it was paid over to your client tomorrow, would that be income that he has now received, which could be taxable? In other words, would it be caught by the argument you have made concerning Section 72 and the fact that income prior to 7 years ago is statute barred from the point of view of assessment to tax? But if you were to receive the funds now, I'd like for you to address that question. What is your view on the taxability of funds that he may now receive from the interest-bearing account? Thanks.
Yeah. Well, our submission is that it is no longer taxable, because for it to be taxed, it means that the commissioner would have to raise an assessment. And so the question is, can he raise an assessment now, 17 years after he purported to do so, and 17 years after he was directed to raise a lawful assessment, or at least told that his assessment was unlawful. And in some instances, in respect of income which is earned as long ago as 30 years. You see, Your Honor, the scheme of the Act, Tax Act, and that section 72 and its proviso, is not to allow the commissioner to raise an assessment at any time. The Act contemplates that he will exercise his powers diligently, and except in the case of fraud, his power to raise an assessment is bound by time limits.
Counsel, if I may,
Yes.
Section 72 is subject to the other provisions of the Act. Am I right in believing that?
But the Act has to be read as a whole, Your Honor. Unless
Thanks very much. Yes, sorry. Yes, the income, quote unquote, the receipt, I should say, the damages receipt, which the appellant had, wasn't this governed by Section 7.2, arguably, of the Act? Doesn't Section 7.2 of the Act itself deals with compensation and modifies the operation of Section 72? I noticed that you haven't made any reference whatsoever to Section 7.2 of the Act. What is the effect of Section 7.2 on Section 72 and following?
Your Honor, as I understand it, Section 72 does not impose a tax on anything. What Section 72 deals with is the powers of the Commissioner to raise an assessment in the event where he's of the opinion that the taxpayer has not been assessed or he's been assessed at a less amount.
Yeah, Counsel, not to interrupt you, but the reason why I'm making reference to Section 7.2, because 7.2 itself is not only...
7 subsection 2, Your Honor. Is 7.
Section 7 subsection 2. I noticed that you didn't mention it in your submissions, written submissions, and it seems not to have been mentioned in the Court of Appeal or in the High Court. But it seems to me that given the factual matrix, given the facts of this case, and the allegation of taxability, that if indeed it is income, it would have to be compensation for termination of employment, which is dealt with specifically at Section 7, subsection 2.
Yes, I noticed that section during my readings last night, but if Your Honor will permit me, I can address it shortly. But
yes, of course.
I'm grateful to Your Honor for pointing that out. But what I was getting at, Your Honor, is a more fundamental problem. We may decide, Your Honors may decide that the whole of the damages and the income from 1990 to 1998 is taxable. The question is, how can it be collected by the Commission? And our submission that it starts with an assessment done under Section 72. Taxation must start with an assessment under 72. And our submission is that in light of the proviso of Section 72, whether or not the monies are taxable, can the Commissioner be allowed to raise an assessment? You see, we need to look at the alternative, Your Honor.
Sorry, Counsel, I'm sorry to interrupt you again, but you said it begins with an assessment. I thought that it started with a tax return being filed by the applicant, by the appellant.
No, that is not how our system works.
Yes, Section 60 of the Act, I think it is. You said it's not it's not how the Act operates. I know that the appellant never filed a tax return and the powers which the Commissioner, powers of assessment, he was exercising the 72 power. But to say that it starts with assessment is that wholly speaking correct? Doesn't it start with a tax return made by the taxpayer?
Your Honor, as I understand Section 70 of our Act, even where the taxpayer delivers a return under Section 72, it is up to the Commissioner to accept that return and make an assessment accordingly. So
that's quite correct. That's quite correct. The only point I was making, Council, is that it's not, in my respectful view, correct to say it begins with an assessment.
No, but I understand, Your Honor. I take the point. But in the circumstances of this case, where he's alleging that no returns were filed, you will certainly exercise to, and which requires him to make an assessment. But the collection.
Counsel, before you move on from there, I was intrigued to read in the submissions of the respondent, or it may have been in their withdrawn cross appeal, the proposition that until the money is received by the taxpayer, there is not any obligation to file a return. Is that correct?
Could you please repeat that, Your Honor?
Yes, I may have seen a proposition that until the money is received by the taxpayer, there is not any obligation to file a return by the taxpayer.
I don't know what support there is for that.
Let me tell you why I raised that. This money was never received by Mr. Ramsahoye. And therefore, I am wondering about the question raised by my brother, Justice Burgess. Could it have started in these circumstances with a return filed by the taxpayer if there is not any money that he received as income on which to, or in relation to which he should file a return?
We could put it another way, I think, Counsel. The liability to pay the tax, does it arise when money is earned or when money is received?
Your Honor, I think in the circumstances of this case, the appellant's liability would have arisen upon payment.
But he has not yet been paid.
Oh yes, he was paid.
Sorry, what was he paid?
Out of the sums that were ordered to be paid to him.
Oh, I see. Sorry. So what was withheld was the tax.
Yeah.
All right. I take a point.
Okay.
Yes. Yeah.
The
And that was
benefit
in 2004, was it?
2004. So
Okay.
monies which were clearly intended for him were demanded by the commissioner, and instead of being paid to him, the employer, pursuant to that demand, paid it to the revenue, supposedly in satisfaction of the tax.
And that is the sum which was supposedly paid into an interest-bearing account in the custody of the registrar?
Yes, that's correct.
So is it the case that what you want out of this appeal is to get back those monies or such of those monies as you think you're entitled to, if not all?
Yes, Your Honor.
That's the entirety of your claim, your relief in this appeal. Is that the case?
Yes, sir. It's basically what we seek are two consequential reliefs. Because, Your Honor, if I may make this point short briefly, if we have to think about the alternative to what I'm asking for. If the commissioner is allowed to raise an assessment now, assuming that Section 7.2 is not applied at this stage, then the points which are before Your Honor, and the points which you're making now relating to limitation, delay, and the like, will be the very points that will be taken in a fresh assessment, which may lead to proceedings. So,
except for 1 year, I think.
Yeah. Well, that was in 2004. 1 year would have been accepted, but by now, 17 years later, nothing could really be recovered, and there's nothing to stop the commissioner from raising an assessment.
Counsel, let me interrupt you here, because there is something which has been niggling at my thinking. Following the decision of the Court of Appeal, and especially in view of the fact that you did not even know, even up until last night, that the monies, the tax withheld, had been paid into court. It seems to me that what needed to have taken place in relation to money paid into court is to ask the court to pay it out. And it is obvious that nobody did, that the attorneys, the representative, the appellant, Mr. Ramsahoye, never applied for payment out. So the misgivings that one may have in relation to the Court of Appeal not making any order in relation to that money may be unfair in relation to the Court of Appeal, that it may not have been for them to do anything. They made a decision quashing that assessment and, as you say, saying it was null. What follows from that? What follows from that is that money, which the Court of Appeal said was not the entitlement of the revenue, is now available for payment out, and the person claiming to be entitled to it must apply for it. Tell me about that.
Yeah. Just a second. Your Honor, that is what you're saying essentially is that that court having not dealt with the matter of payment out, that court
wait. Why you say they haven't dealt with it?
They were not asked to do that. That's my point.
Yes, but there was an order, Your Honor, saying that the money is to be lodged. I understand your point. It would have been
the money just wouldn't magically come out of that account and go into somebody else's account. Somebody has to go to the registry, say, here is this order saying that this money is frozen until this appeal has been heard. The appeal has been heard. I am now asking that this money be paid to me. Somebody
and you make a formal application, filing papers in court. I have done it before. I'm sure you have done it.
Yes, sir. Yeah. But if it is something, the Court of Appeal could have done, and if it didn't do so, our submission is that Your Honor can do it and put an end. It is a consequence.
And Mr. Sakram, what is troubling me is this, that maybe we do not even need or did not even need to be here. Had an application been made for payment out, then the question would have been, on what basis would the court in Guyana have refused to pay it out? Would they have refused? It was entirely within the competence and the compass of that court to pay this money out.
Of course, Mr. Satram, the issue I raised with grounds on the other side is important as to when the funds were paid in, but we haven't sort of drilled down beyond that question. Yes. But I wanted, once you have responded to my brothers, to give you the opportunity of explaining for my benefit, so I'm comfortable with the idea, as to why funds which are now received by your client, let us say that they were to be received tomorrow, would not be susceptible to assessment. In other words, are you relying exclusively on 72 to inoculate any such receipt from assessments, or do you want to develop the point any further? I don't know that in your submissions you did. You did, of course, allude to 72, and you did allude to the general principle that it would be unjust, etc., etc. But I just wanted to give you the opportunity to develop the point further, if you wish to, as to why funds now received would not be, in your view, susceptible to assessment by the revenue. Thank you.
Thank you, Your Honor. Your Honor, we rely in support of that, our position on that, essentially on Section 72. Because the order of the Court of Appeal says that we can now make an assessment in keeping with the statute. But the section which allows for the raising of an assessment itself creates a time bar. It doesn't allow the Commissioner to go back more than 7 years. And this is whether or not a return has been filed, except where there is fraud or any gross or willful neglect. The Commissioner did allege fraud and neglect and so on, and it wasn't established, and the trial judge found that there was no such fraud or neglect, and that wasn't disturbed by the Court of Appeal. So we're left now with the question of can he raise an assessment?
Let me interrupt you right at this point, Mr. Satram.
Yes, sir.
I got the sense, and it may have been my converting what I heard into maybe some pre-existing thought. But the last sentence in the Court of Appeal's determination, or the last two, in this regard, we uphold the trial judge's findings and his quashing of the assessment by the Commissioner. And then this, and I think I may have misread this. We order that any assessment must comply with the procedures and processes established under the Act. And I think I was reading that to say that the Court of Appeal was saying, go back and make a new assessment. But I think I am wrong. I think what they were saying was simply emphasizing the sentence which went before, that the quashing stands because we declare that any assessment must comply with the procedures and processes established under the Act. So the order is, with respect, superfluous and perhaps misplaced. They are not ordering that there shall be an assessment. They are making a determination which may have been helpful. It may as well have been simply advisory. We order that any assessment must comply.
Well, that's why we say, Your Honor, that an appropriate consequential order to put the matter to rest would be to say that he cannot now make an assessment.
And that's exactly the point, Mr. Satram. The Court of Appeal did not need to make it, and it seems to me, as presently advised, just for purposes of this segment of the discussion, that we also do not need to make it. We also do not need to say that the Commissioner needs to do this. What he needs to do is entirely his or her business. What we need to do is to make a determination as to whether the failure to apply for payment out is not in fact determinative of this matter. And further, since the questions have arisen, whether the quashing, that is not challenged. Whether the quashing was properly done is not any longer before us.
Your Honor, I don't know how Your Honor see the order, but at page 17, the order seems to be addressing the future conduct of the Commissioner. It says that the provisions of the act as the notice of assessment, objection, or appeal must be complied with. It is not saying that it wasn't, it said in the judgment that it was not complied with, but it goes further than that and saying that it must be complied with. It was clear that it was not complied with.
Where are you reading from?
The order of the court at page 17 has entered. That's the only thing that is in the order. There's nothing else in the order.
Page 17.
That's the order of the Court of Appeal. It's further ordered that the provisions of the Income Tax Act, Chapter 8101, as the notice of assessment, objection, and appeal must be complied with in relation to the respondent. Now, what was the ground on which the Court of Appeal, in effect, quashed or disapplied the assessment?
Well, its reasoning is found at paragraph 30 of the judgment, where they said they agree with the hearing judge that the processes provided for in 72, 78, 82, and 86 were not followed or complied with your briefs.
Mr. Satram, the order which you just read out, I've read it, thanks. What does that order do? An order is, as one understands it, a declaration or an order is dispositive. What does that order do? Who is to do what pursuant to that order?
So you see, Your Honor, this order will validate any assessment that the commissioner may now make.
But that's exactly the point. So it is advisory. And it is not that
it is the danger. Because
yeah, but it is not that, if you may allow me, it is not that it will validate any assessment. It is that if the commissioner makes an assessment, this order is saying that that is how you must do it, if you make an assessment. The court is not saying, as I misapprehended it, that we will hold on to this money and give the commissioner time to go and make a new assessment, which we are telling him must comply with the provisions of this act. The court, it seems to me, went further, helpfully no doubt, to say, listen, any assessment you may come with after this has to comply, because we have already told you the one which was struck down for non-compliance, and therefore any new one has to comply.
Now, you are saying that any new one is incapable of compliance. Well, so be it. If it is made and it is incapable of compliance, then let the chips fall where they may.
Your Honor, all I'm saying is this. I understand clearly.
You're saying more than that, it can't now be made.
Yes, that's what I'm saying. Because of this, let's assume what the Honorable President just said does in fact happen. We end these proceedings and no consequential orders are made. We're turned away. The commissioner then relies on this order, which appears to be permissive, and raises an assessment, and he may or may not comply with the procedures. Assuming he complies with the procedures, we will then take the same points which have been raised before, Your Honor, including all the way down in the lower court, and that have been answered by the commissioner already. The commissioner.
Okay, so you want us, Mr. Satram, to restrain the commissioner from making any further assessment in this matter?
I would the complete and final disposition of this dispute. An appropriate consequential order would be to declare that we cannot now raise an assessment in light of Section 72 and the delay. And that will put an end to everything, because when he raises this assessment, remember, Your Honors, the limitation argument was raised in the High Court, and the commissioner did answer it. He said that the man committed fraud and that the fraud is borne out in the record of appeal. It was raised. The limitation argument was raised. It is not being raised for the first time.
But counsel, counsel, with respect, doesn't Section 72 deal with a situation where one is dealing with income received in different income years? Is it dealing with a lump sum payment, as in the case of the damages which were paid, and which, if exigible to tax, would be taxable under section, in accordance with Section 7.2? Doesn't 7.2 deal with a lump sum payment, compensation, potentially, in a given income year? And doesn't it set up a procedure for dealing with that payment over the years that the compensation covers? You make reference to 72, but I'm just wondering aloud whether 72 is the applicable provision in the circumstances of this case. It may very well be, but it doesn't seem to me that you have, certainly from my perspective, that I am clear as to why Section 7.2 wouldn't avoid the limitations argument that you're advancing.
I'll address both of your concerns, sir. The assessment, as far as 72 is concerned, is to be raised in respect of each year of assessment.
Precisely.
Yes.
Precisely. But we are dealing with a lump sum payment which was made in a particular income year. We're not dealing with a lump sum payment alone, Your Honor. I agree. I agree with you that there's income which was payable in separate income year. You're quite right in respect of that. But the major income that we're dealing with is the damages awarded by the court. Am I wrong in believing that? That lump sum payment.
That may not be accurate, Your Honor, with respect of the sums that were collected, 225,000 US, only 56,000 United States dollars represented the tax on the damages component. Remember, a large part of the monies awarded to him represented arrears of pension.
Yes, but that was part of a lump sum payment, wasn't it? That was part of a lump sum, wasn't it?
Yeah, part of the lump sum.
And pension payable over a period of number of income years. Am I wrong?
Yes, sir. But the court.
I'm wrong?
No, sir. They're saying that the pension was not taxable. Commissioner himself accepted that it was not taxable. He raised two forms of taxes he would pursue. $56,000 being the tax and the damages, and $165,000 United States dollars being the Paye deductions, which should have been made from 1990 to 1998. And he was raising that assessment for each year of assessment in the year 2004.
Yeah. In what year was the appellant terminated?
1998.
1998. That's what I thought.
We stopped at 90. But secondly, in respect of the Section 7 subsection 2 argument, let me get the division. I'll address Your Honors briefly on I'm almost out of time, on the damages, the taxation of the damages. Now, the case of Gorley or whatever, the House of Lords decision, is not authority for the proposition that damages are taxable in the hands of the recipient. I think as I read the case, it says that there should be this notion of deduction or accounting for tax. Most cited and relied upon by the Court of Appeal considered language which is vastly different from our Income Tax Act, Section 5B of our Income Tax Act. It considered the English 2013 Income Tax Act. Now that the UK legislation considered in that case introduced much wider language so as to capture compensation directly or indirectly. That is the language we use, related to the termination of employment.
Sorry, remind me where you have that authority, the UK tax? You don't need to turn it up, just tell me where you have it.
It's in the Murti case, and that case, it was discussed at length by Lord Justice Henderson, I believe, at page 423 of the record. That is where it begins.
Thank you.
So just to be
yes.
just to be clear, Mr. Satram, what is precisely the difference that the Guyanese statute refers to compensation for termination,
Yes.
and the English
UK
statute refers to direct or indirect compensation? Is that the nub of the difference that you're pointing us to?
Yes, sir. Directly or indirectly related to the termination of employment. The legislative history was traced at paragraph 32 of that judgment, at page 432 of the record. It began with an amendment made in the United Kingdom in 1960. And before then, their legislation was essentially in terms, in the same terms as our legislation. And that is why, Your Honor, we rely on the Privy Council decision in Haywood. In the Haywood case emanating out of Malaysia, that case is at page 413 of the record.
Except, counsel, that didn't deal with damages. That was an ex gratia payment by the employer, wasn't it? So it doesn't really take us very far in respect of damages. It did discuss compensation, but compensation in the context where the ex-employee was an ex gratia payment was made for his termination by the employer. It was not a court. It was not a court award of damages, was it? And does that make a difference? It's a factual difference, but does it? I'm just making the point to see whether you think that that's a consequential distinction.
I follow you, Your Honor. It did construe the term compensation for loss of employment. And I don't see why it wouldn't apply to all forms of compensation, including damages, which is the most common form. But
yeah, but is payment ordered by the court the same as an employer saying, okay, I will pay you out? Is there something, is there a difference? I agree with you. I think you're thinking that damages are basically compensatory, but are they compensation? Because that's what I'm not certain.
I follow you, Your Honor, but the way the problem has been analyzed is whether, and this is what I believe Lord Viscount Dilhorn said in the Privy Council case of Haywood, is whether or not the payment is attributable or is being made under the agreement, under the contract of employment. And that is what determines whether it is compensation that is taxable under that section. Because the legislation in Malaysia is almost identical to ours. And there's another reason, Your Honor, why that interpretation is correct. Because if, according to Gorley in these cases, the court is bound to deduct or to take account of taxes when assessing or computing damages, it can't be that those damages which takes account of taxes are taxable again. Can't be taxed twice. And that is why when we look carefully at the UK legislation, certain elements of the damages, of a damages award, are exempted from taxation. because of that.
Counsel, I'm sorry to interrupt you again, but I've always learned that taxation is the edict of the Parliament concerned. That is, the Guyanese Parliament, as it expresses intention in the Act, is superior to, not superior, but that's the only thing that matters, not what happens in the UK. And I thought that earlier you yourself made the very important distinction in the Murty case, because the language of the statute was different. So are we looking for a common law of taxation, or is this based on what the Guyanese Parliament intended?
Your Honor is quite right. It is clearly a matter of construction. All we are offering is an interpretation of what we think the section is saying, because it is a matter of statute. Taxation is always a matter of statute, as Your Honor said, and the statute must be construed restrictively. I think that is another principle which governs it. It is not to be construed liberally, and Your Honor will remember that Section 5B is, after all, a provision taxing gains and profits from employment. What follows are examples of what constitutes gains and taxes from employment. So if we construe it restrictively, we take into account that damages awards already include a deduction for taxes, then it's difficult for us to say that it's taxable again.
But that's in the case of personal injuries, but I'm not certain you're right. Where contractual damages are awarded, that account is taken of taxation liability.
Well, I haven't seen any authority specifically in that, but the general proposition as laid down in the Gorley case is that we should try and bring the award as close as possible to what he would have realistically received. The same, I don't see why it wouldn't apply to loss of employment, damages for loss of employment.
Is it because contractual damages are awarded on a different basis from tortious damages, and in personal injuries, you're basically talking about a different basis for taxation? You don't have to pursue it. I'm just thinking aloud. If you want to, you can.
Well, we're concerned, Your Honor, here with what is meant by compensation in the statute. Use the precise language. Compensation for the termination of any contract of employment or service. That is what we're concerned with. Does it relate to those gains which are payable pursuant to the contract, or does it extend to include damages awarded by a court for repudiation or whatever injury the court feels must be compensated, for which the taxpayer must be compensated? That's the question. And of course, it must be construed restrictively, and we must remember that what the section creates a charge on gains or profits from any office or employment. So the question is whether damages is to be regarded as a gain or a profit from employment. On the PAYE question, I wouldn't be long on it, but I did refer Your Honors to Regulation 12 of the income tax deductions of regulations found at page 849. It says that the employer remains liable to the commissioner to pay the taxes unless the employer has some reasonable excuse for his failure. Your Honors will see that Regulation 11 says that it is a debt to the state owed by the employer.
I'm sure you're not seeing the argument by counsel for the other side on this point. And I don't know whether you wish to respond now. I think essentially the argument is that the request, the imposition was not being made of the employee. It was directed to the employer. Nothing in the communication said that it was reflective of an imposition on the employee. So did you want to respond to that now or later?
Whose money was the employer asked to pay out? I mean, there was a judgment there due to the employer.
I'm asking you the questions. The point is that I believe that the other side has made a very interesting issue, and I will just give you the opportunity of responding to that.
Yeah. The commissioner was clear that what he was asking the employer to pay over were PAYE deductions which should have been made from 1990 to 1998. I think that is clear. He was saying in essence to the employer that you have failed to make these deductions. And I now want it to be paid out of the monies you have there sitting for the taxpayer.
Did he say that?
Well,
Well, Mr. Safran, very helpfully for you at paragraph 21 of the respondent's submissions, I think they proffer their own view that an examination of the correspondence between the commissioner and Linmine will reveal that at no point in time did the commissioner generally indicate that the appellant was personally liable for the PAYE Linmine failed to deduct, nor that the outstanding PE should be deducted from the judgment sum awarded to the appellant. It was Linmine of its own volition that deducted the PAYE sum from the judgment sum awarded to the appellant.
Do you find that helpful, Mr. Sartre?
I didn't get that, Your
I know, I was wondering if you found it helpful, as my brother was indicating.
Yeah. And there's an explanation at paragraph 9 of the affidavit in answer.
Yes.
At page 75 of the record. He was saying why they couldn't deduct it. So they're not being paid on time or something like that, which I don't understand. But there's another point which applies to the PAYE.
So before we move on to this other point, I think you're conceding, well, I'm asking if you're conceding then that you can't point to any definitive statement in the communication from the Commissioner General in which he's indicating that the liability to pay EYE is that of the appellant. You're willing to concede that, I take it.
I will have to say so, but
Thank you.
Was, yes. And he did seek to explain it in his affidavit. But that aside, even if it was recoverable against the employee, the recovery, or at least all except for 1 year, was barred by the proviso to Section 72 since then. I don't know.
Let me ask you a question, Mr. Satram. Would you, for the disposal of this matter, would you be prepared to concede the payment of that 1 year
Okay. I suppose so, Your Honor. I suppose so, because, Your Honor, my client has been fighting up behind this thing for a very long time, and now, if there's a way that we can bring it up, I'm sure you will agree. Because, quite frankly, he's tired, and if he has no resources to pursue this fight, he has no pension at the moment, and if a fresh assessment is raised tomorrow, or whenever Your Honors decide this case, it will have to be challenged again. It may take another 20 years for that to come to an end. It's really, really oppressive, very oppressive.
Yes. Well, you're almost out of time, huh? Anything else that you want to say?
I don't think so, Your Honor, except that I urge Your Honors to put an end to the dispute and make the consequential order that we pray for. Put an end to it. Most grateful.
Yes, thank you.
Your Honors, Ms. Halley will be the lead advocate in this case.
Yes.
Good morning, Your Honors.
Good morning.
Good morning, Counsel.
Good morning, Your Honor. Your Honor, before I proceed, and having regard to the submissions made by counsel for the appellant.
Through you, Mr. President, could I just ask that we be graced with a better version of the speaker? Or should I say a more direct version of the speaker? I am being deprived of seeing counsel while she's making her submissions.
Most certainly, Your Honor.
Yes. Thank you.
Yes, Your Honor. Before I proceed with my submissions, and having regard to the submissions made by counsel for the appellant, is there any specific area or any point that Your Honors would prefer me or to respond to?
If I may take you up on that.
Dangerous one.
Of the location of these funds. I'm hearing a great noise.
President, you're muted.
No, I just muted because of the great noise. It's gone now. Yes.
It's gone now, yes.
Yes. Yes, counsel, to the proposition that these proceedings would have been unnecessary had there been an application for payment out of that money. Tell me about that.
Well, Your Honor, I believe it was only yesterday that counsels for both parties actually discovered that the sum was actually lodged with the registrar of the Supreme Court in an interest-bearing account.
You should cringe. You should cringe at making that admission, although it's an explanation.
It is embarrassing, Your Honor. Unfortunately, that order did not form part of the record of the Court of Appeal. And maybe that is one reason why the issue was not addressed by the Honorable Court of Appeal.
That does not answer my question. I understand why the application was not made. Believe you me, I'm very clear. Nobody knew where the money was. Nobody bothered to pursue the inquiry as to where the money was. So I'm very clear on that. Now, that being clear, the question is, given that everybody, those who were interested in the money, ought to have known from the time of the Court of Appeal proceedings where the money was, the question is, had an application been made after the judgment of the Court of Appeal, quashing or upholding the quashing of the assessment, would that not have disposed of this matter?
Well, Your Honor, that application might very well have disposed of this matter.
You have answered me. Please continue.
Your Honors, counsel for the appellant, of course, has conceded on the issue of the PAYE deduction. However, I would still like to address the court on the issue if the court has no objection.
Yes, proceed.
Your Honors, Section 93(1) of the Income Tax Act requires any employer making any payment to employees to deduct relevant taxes and submit same to the Revenue Authority. Regulation 12 of the Deduction of Income Tax Employment Regulation, a copy of which is reproduced on page 82(1) of the court's record, stipulates that...
On page what, 821?
Yes, please, Your Honor, 821 of the court's record.
Yes.
Regulation 12 stipulates that if an employer fails without reasonable excuse to deduct the relevant taxes, then the employer is not liable for those taxes. Now, in the present case, Linmine failed to deduct PAYE from payments made to the appellant. The Commissioner General at the time wrote to Linmine instructing that deductions for the period January 9, 1990 to May 1998 were to be deducted and remitted to the Revenue Authority.
And what's the date of that letter?
My apologies, please, Your Honor. The letter is dated September 24th of September, I believe, 2004. My apologies, Your Honor. The letter is dated September 29, 2004, and it is reproduced on page 67 of the court's record. Now, in that letter, the Commissioner General clearly stated that the onus was on the employer to deduct and submit the PAYE that should have been deducted during those relevant periods. At no point in time did the Commissioner General indicate in that letter that the said sum was obligated to be deducted from the sum awarded to the appellant by the court. Now, counsel, of course, has raised the issue of GRA's failure to send formal notices of assessments to the appellant. Your Honor, the Income Tax Act makes no provision for a formal notice of assessment.
So before you go further there, could we just go back to the PAYE point, just to clarify something for me? As we have heard this morning, the courts really have been severe on the procedure adopted for assessment by the Commissioner General, and they have suggested that the correct procedure wasn't followed. Was that a ruling? I'm just trying to get it clarified in my own mind. Would that ruling also cover the assessment to PAYE or not?
Well, Your Honor, in our opinion, no. Reason being, PAYE is a special mechanism that is created by the Income Tax Act due to the nature of the tax. For ease of collection, employers are required to deduct taxes from their employees. It would have created great hardship if GRA was required to collect taxes personally from each and every employee. Every month, employers are required to deduct the relevant taxes and submit same to the Revenue Authority. The employer is also required to submit a return containing a list of the name of the employees and the amount of taxes deducted.
So this is a deduction, so that nothing is payable unless there is something from which to deduct. Is that correct?
That is correct, Your Honor.
When did something arise from which a deduction could be made?
That would have been when the award of damages was made to the appellant. Reason being, monies are only being income from which.
But isn't this just a method of getting the tax? For example, Section 72, which has a limitation provision, does that not apply to this form of tax?
It does, Your Honor.
Yes. So to ask in 2005 for the tax going back to 1990 wouldn't be in accordance with 72, correct?
Well, Your Honor, Section 72 deals specifically with the raising of assessment.
Yes. So are you saying that, because you said 72 applies to this kind of tax too, so does that mean that in 2005, the commissioner could go back to 1990? Is that there is no limitation whatsoever?
Well, Your Honor, it is my belief that in a situation like that, Section 7 is the applicable provision.
Okay.
This is Section 7 of the Income Tax Act.
And that tells us what?
Now, Section 7 refers to situation where remuneration or compensation for the termination of contract are received in a later year. For instance, in this case, the appellant was terminated and the court subsequently awarded income for the remaining years of his contract, which was equivalent to 41 months.
Yes.
Now, assuming that those money are deemed income and are subject to tax, then based on Section 7, those money would have been taxable in the year in which it was received, which would have been the date or the year that the appellant received payment of the said sum.
But I thought that you were saying that this kind of tax should not have been, and that in fact the commissioner didn't ask to deduct that from that amount of damages. It should have been asked of the company. That is what you said, didn't you?
What I said is that the commissioner asked the company to submit the PAYE that he should have deducted during those years on behalf of the employee.
Yeah, so wasn't it the company that had to pay that?
Yes, the money should have been taken from the company and not the award of damages.
But the commissioner, knowing that it was taken from that amount, nevertheless accepted it.
Well, Your Honor.
Well, isn't that so?
The commissioner requested payment and he accepted payment.
But he knew at least at some time that was taken out of the amount of money that would have to go to Mr. Ramsahoye, correct?
Well, unfortunately, I can't say whether he was aware of that.
Well,
Counsel.
Yes,
there
Your
are
Honor.
certain things to which you can say yes, without violating your adversarial stance. The commissioner absolutely had to know.
I'm guided, Your Honor.
So as I understand it, your case is that when the award was made for these monies to be paid, it is at that point that the revenue was entitled to say to the company, pay less the PAYE earned and pay me the tax which is imposable on the salary for which he's gotten this deferred payment. That's your case?
Yes, Your Honor.
And that amounts to the $45 million?
Well, Your Honor, the $45 million was in relation to undeducted PAYE for the period January 9th, 1990 to May 31st, 1998, and income on the judgment sum. So it was two separate payments that resulted in $45 million.
Is there a disaggregation of the sums? How much amounted to the PAYE and how much amounted to the income? And you need to tell me a little bit more about this income,
Yes,
tax
please.
on other income.
Your Honor, if the Honorable Court would be guided to page 67 of the record, the Commissioner General, in his letter dated the 29th of September, explained to Linmine that PAYE was due and payable in the sum of US $167,065. And in the following paragraph, he stated that income tax was payable on the awarded sum in the sum of US $4,039.
I don't understand something here. So the damages awarded amounted to sums in excess of the deferred salary.
That is correct, Your Honor.
So the revenue is saying, well, pay me the PAYE on the salary.
Yes, Your Honor.
And then on the rest of the money, you need to pay me tax on that sum. But for that rest of that money, wouldn't an assessment have to be made?
Yes, Your Honor. An assessment would have had to be made.
And that assessment was effectively struck down by the court.
That is correct, Your Honor.
So on what basis is the revenue still holding that portion of the money? Well, it isn't holding it, but on what basis does it have a claim, an entitlement to that portion of the money? When currently there is no extant assessment.
Your Honor, the Revenue Authority believes that in the interest of justice, that the taxes payable on behalf of the appellant should be received by the Revenue Authority. The reason being is that taxes are a debt that is owed to the state.
Yeah, that's all well and good. That's a kind of moral argument, but we're in a court of law. And the issue is, I could understand you disaggregating the sum into two portions. What is payable by the employer as PAYE and the rest. I'm saying in relation to the rest, is there any automatic manner, in the same way that you can automatically almost discern what's the PAYE sum, because there's a formula. But in relation to the rest, what would be the normal manner of collecting such sums?
Well, Your Honor, the taxes that was imposed on the award of damages was the same as PAYE. The award of damages was calculated based on the terms of the employment of contract. The appellant was paid for the remaining 41 months on his contract. And pursuant to Section 5B of the Income Tax Act, income tax is payable on any gains or profit from any office or employment, including compensation for termination of any contract of employment. It is the Revenue Authority's respectful submission that the sum awarded by the Court of Appeal to the appellant is compensation for the termination of his contract of employment and is consequently subject to income tax.
Counsel.
Yes, Your Honor.
If I may, I think that your case has to be that compensation for the termination of an employment contract is income within the contemplation of Section 5(2). Is there any definition of compensation within the Income Tax Act? I didn't find any.
No, Your Honor, there's no definition of compensation within the context of the Income Tax Act.
Is damages really compensation? Can it be described as compensation? If one gives compensation the strict interpretation which all of us agree should be given to taxing statutes, would compensation, don't you have to argue us to a conclusion that compensation in its ordinary natural meaning includes damages?
Well, Your Honor, compensation does include damages.
And how is that so? I mean, aren't damages something which are ordered by the court?
Yes, Your Honor, damages are something that is ordered by the court.
But is the court doing that by way of giving him compensation?
Well, Your Honor, the court is, in this case, the court ordered that the employer compensate the employee for the wrongful termination of his contract.
Pays damages, I think, was the order of the court.
That is correct, Your Honor. But, Your Honor, I think we need to look at the nature of the damages and how it was calculated. In essence, what the court ordered is that the appellant be paid his monthly salary for the remaining of his contract.
But his employment had disappeared. By the time he was ordered to make that payment, his employment had disappeared.
Well,
so how can, even if the basis of the payment was what he used to earn, there was no employment, and the section says that income is gains or profits, from an employment. Were there gains or profits from an employment?
Well, Your Honor, the source of the money was from his former employee.
Sorry, but not every occasion you get money from your former employee, will it amount to compensation, or will it amount to income? I'm certain that you will concede that.
Yes, Your Honor, that is correct.
Which leaves us still with the task of deciding that damages are compensation for the purposes of Section 5(2) of the Income Tax Act. Are there any cases that you could cite to us that would help us to decide this point?
Well, Your Honor, unfortunately, I don't have any authority that speaks to damages specifically as compensation for termination of employment. The only authority we relied on was Marti and Revenue Customs Commissioner. But in that case, the payment was an ex gratia payment and not damages awarded by the court.
Well, I'm glad that you made the distinction. I think counsel before you made the distinction, and not only was that the case, but also the language was not compensation for termination. It was rather different, wasn't it?
That is correct.
Thank you.
Counsel, if I may take my brother's line of inquiry a bit further for my own clarification. What is paid by way of damages is damages or compensation for the wrongful termination of the employment. And the amount of damages, the amount of compensation would take account of what was lost, so that in relation to the Gordy case on which Mr. Setram finds great comfort, in Gordy the point was made that a court can itself deduct from what it is going to pay or what it is going to award to be paid to a dismissed employee. The court can deduct and withhold or not include in the damages that amount which, had the employee received the income, would have been paid to tax. So that if an employee was getting $20,000 a year and would have to pay $8,000 a year as tax, then what a court may choose to do is to award $12,000 as compensation. There is no tax being paid by the employee. The revenue does not get the $8,000 withheld by the employer, withheld by the court and not ordered by the employer to be paid. The court does not say to the employer, and by the way, that $8,000 which you would have had to pay had you been paying income, pay that to the revenue. That is not what takes place. So I think that may demonstrate the line of inquiry from my brother, and it seems to me to clarify my thinking in that regard. Is there any gloss or correction that you would wish to offer in this regard?
No, please, Your Honor.
I have a question also. You would agree that the Court of Appeal upheld the trial judge's quashing of the assessment by the commissioner? That's what they said?
Yes, Your Honor.
You would agree that there is no appeal against that decision?
Yes, Your Honor.
Okay, so logically, that would mean that that's the end of the story as for now, but there is some idea of, okay, then maybe later the commissioner could still assess or make the assessment that is necessary. How do you see that against the existence of Section 72? Because that was breached. One of the sections that was breached, according to the Court of Appeal, was Section 72, which contains this limitation. If it was breached then, wouldn't it certainly be breached now? Could you get into that? Because I think you would agree that at some point we need to find closure for this case. Mr. Ramsahoye, this gentleman, has been waiting for decades now for a solution in this case. He's not getting any younger. And I think whatever we do, it needs to be a definitive solution. We can't drag it on. So what are your thoughts?
And whilst you're answering my brother in relation to this, maybe you could just clarify, because I'd asked you before the scope of the order by the court and whether it included the Paye deductions. So maybe you should take that into account when you're answering the scope of 72. Thanks.
Your Honor, in regards to Section 72 of the Income Tax Act, the Act, of course, clearly sets out a specific timeline for the raising of an assessment by the Commissioner General. It also contains a proviso for the raising of assessment outside the normal time, where there's any discovery of fraud or any gross or willful neglect. Having regard to the Court of Appeal's ruling that the assessment was unlawful and conducted contrary to the statutory procedures of the Income Tax Act, it would appear that the Commissioner does not have the authority to raise an assessment under the circumstances.
Yes, I think the issue of the fraud was decided by the High Court judge, that there was no such fraud. And I don't think that that was appealed by anyone in the Court of Appeal. Is that correct?
Yes, Your Honor, that is correct. That was not
Okay,
a point that was raised in the Court of Appeal.
Okay, so that point is settled then. So so then we are stuck with the limitation period mentioned in 72. And you would say that if there is to be another assessment, that is going to be difficult because of that same section 72. Is that correct?
Your Honor, there might be some amount of difficulties, but Your Honor, it is our belief that this honorable court has the power, in the interest of justice, to extend the time for the raising of an appeal, of an assessment.
Yes, well, I'm not sure if that is in the interest of justice, but...
But sorry, where would that power come from?
Well, Your Honor, I believe in the case of Guyana Stores Limited and the Attorney General and others, a case decided by this Honorable Court in 2018 at paragraph 45.
Which case is that?
Guyana Stores Limited and the Attorney General of Guyana.
Yes.
At paragraph 45 of the decision, this Honorable Court stated that broad consideration of justice beyond the strict application of law give rise during the hearing to considering whether it would be competent and appropriate for this court to send the challenge to the liability for tax to go through the review and appeal process. I believe in this case, Your Honor, the time had passed for the appellant to file an appeal to an assessment. And this is something that the court considered. However, having regards to the facts of the case, this honorable court
But there is no assessment. It was quashed. And that decision was not appealed. So yeah, we have to go back to making an assessment first. And then you got stuck with 72, I thought. But I might be wrong, so you can explain to me why that would not be correct. But
just a minute, please, Your Honor. Your Honors, unfortunately, I will have to concede that Section 72 is clear and would bind the hands of the Commissioner General.
So where does that leave you?
Well, sorry, before you answer my brother, and in answering him, could you consider the question, is there any reason why this court should not, in its disposition, given the quashing, which you, I think, accept stands, is there any reason why this court should not state in its disposition and the funds paid into court shall be paid out to the appellant? So answering the President's question, where does that leave you? Could you include that in your answer?
Could you please repeat your question, Your Honor? My apologies.
Yes, the President asked you, since you accept that under Section 72, the Commissioner basically cannot levy or raise another assessment, my question is, in answering the President, could you consider the question, what would be the reason for this court to refrain from ordering that the monies paid into court shall now or shall forthwith be paid out to Mr. Ramsahoye? What reason should stop us from doing that?
Well, Your Honor, to answer your question, I think we need to go back to the decision of the Court of Appeal. In allowing the appeal in part, the Court of Appeal determined that the award of damages or the sum awarded to the appellant was subject to income tax under Section 5 of the Income Tax Act.
In principle, it said, in principle, don't ever forget that in this context.
I'm guided, please, Your Honor. Well, Your Honor, in that case, it would appear as if the Revenue Authority is without a remedy.
Sorry, the question of being without a remedy does not arise in it. The question is whether the Revenue Authority has any basis for resisting the natural consequences of the Court of Appeal's decision, which has not been challenged. So there's no question in these proceedings of a remedy.
Your Honors, it would appear that we would have to be guided by whatever order this honorable court makes.
Counsel.
You always would have had to have been.
Counsel, if I may add, I heard you blow a sigh a bit earlier, and I see your difficulty, and I just want to pay tribute to you for, notwithstanding the bitter remedy that you are asked as in childhood to swallow, you have done with distinction or with accomplishment your job of representing your clients. So do not in any way feel that you have not done as well as you could. Allow me to say that.
Thank you, Your Honor.
Is there anything else that you wish to say?
No, please, Your Honor. Those are my respectful submissions.
Yes. Mr. Satram, do you wish to say anything?
Just one short point in answer to something that was being raised and pressed by Justice Burgess. There is in the definition section of the Act, Section 2, a definition of emolument. An emolument is defined to include remuneration. And remuneration itself is defined in Section 2 to include compensation for the termination of any contract of employment or service, which is the very phrase used in Section 5B. So I suppose that can assist Your Honor in construing that Section 5B. That is as far as definitions go. Because remuneration would ordinarily refer to monies earned under contract. But that is all I wish to say, Your Honor. I thank Your Honors as usual.
Just a minute before you go. I was intrigued by the issue of the PAYE monies. Is the Commissioner obliged to raise an assessment in relation to PAYE?
Yes, please, Your Honor. It is essentially a tax, an income tax, Your Honor. It is a charge to income tax. All it is a mechanism for the payment of advance taxes based on the previous year's assessment. So the taxpayer is still required to file a return, and in an assessment, the Commissioner deducts the advance tax. So it is income tax. It's nothing else. It's
okay,
really
advance tax. Okay, I got you. I suppose we get back to the same point. This appellant, this taxpayer, did not file a return, and therefore it fell to the revenue to raise an assessment. And their case has been that, one, yes, the purported assessment was quashed. And I think secondarily, in the alternative, even if it were held valid, 72 caught it, and therefore only 1 year would have been liable to taxation, or the assessment could only have covered 1 year. Am I correct?
Yes, sir. In 2004.
Yeah. But your primary argument...
The delay, the circumstances have changed. And now the entire thing may be caught by Section 72.
Yes. Okay, is there anything else that you...
No.
And just to be clear, ex abundante cautela, in relation to the question I raised with counsel opposite about the coverage of the orders quashing the assessment, I presume it's your view that those orders covered the PAYE assessments as well?
Yes, Your Honor, because if Your Honor looks at the order, it was an order quashing the decision contained in the letter. I think the order specifically said decisions contained in the letter of the 29th September. It must be taken to mean the whole thing.
Yes, I thought counsel took us through a very helpful analysis of the concept of the PAYE tax, but in terms of the coverage of the order, I think what you say seems to be consistent, at least at this point in my mind, with the order issued by the courts. Thank you very much, counsel.
Much obliged, Your Honors, and thank you as always for the audience. I don't know when we'll be able to return to Your Honor's court, but I hope sometime soon. Physical hearing.
Yes, let's hope for the best. Sometime in the year, perhaps.
Much obliged.
Yes. All right, thank you very much, counsel. We will let you know of our decision as and when we are ready to give the same. Madam Deputy Registrar, can you please close the proceedings?
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess. Counsel, thank you kindly for being here with us. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.